Nicholas, who should know better, has on 3 occasions this morning asked me, what are you going to do with your panel? And each time I have said to him, completely honestly, I don't know. I don't know. You know, we are, in a sense, a panel about the future beyond the future. In the sense that for a day and a half now, the panels have talked about the future given artificial intelligence. And now, in a loose sense, we're asked to talk about, well, if there's a future about artificial intelligence, what is the future of that future? In other words, in a world in which we know very little, this is a panel about knowing almost nothing. So, I will say to you, I have not said anything to them. I don't believe in talking to fellow panelists ahead of time. I believe in spontaneity, for better or for worse. We're going to have a bowl session. It's a bowl session. All of us, you included, we're in Nicholas's living room. He has a big living room. You know, he's a corporate type. And there's beer and pizza. Or if you're from California, white wine and sprouts. And we know each other, sorta. We don't necessarily like each other, and we don't necessarily agree with each other. It's the perfect environment for a bowl session. And you are invited to the bowl session. We'll try to have some regularity to this. We'll try to organize the anarchy I'm describing. We will continue for everyone out here. If you have that impulse that you want to say something to a panelist, or just say something or ask a question, just go to the mics. My peripheral vision is still intact. Don't get too frustrated if I don't come to you 30 seconds after you appear there. We'll see. You've met all these people before, except Julie, I'm not sure you've been introduced.
I actually believe I was introduced. Is this on? I can introduce.
Yeah, give us a short paragraph.
I am an in-house lawyer, general counsel of H5. For 10 years before that, I was an in-house counsel at Philip Morris and Altria. And prior to that, I was a litigator at Davis Polk in New York, doing all kinds of litigation. So that's the heart of it. I teach as well at a competitive school uptown, technology and the law for technology professionals.
Down here, we don't recognize that there is
a
an
competitive
uptown.
school. Oh, I didn't think you thought there was a competitor. Okay.
Life ends at 14th Street. David, you moderated the immediately preceding. Do you feel the need to say anything more about yourself?
No, I'll rest.
Rest. Good. Rest is good. Jeff, you moderated first panel this morning.
Same.
Now, we are not related. We are colleagues. We are both members of the NYU law faculty, but we are not related. Now, you met Nicholas first thing yesterday morning, but conferences like this have a float. Some of you were here yesterday morning. Some of you were not here. Who are you? What should we know about you?
That I live a conflicted life between the two hats that I wear daily. One is the CEO of H5, a company that I think is generally credited with having pioneered artificial intelligence in civil justice. And In that, I have advanced and promoted AI. And the other hat is that of a concerned citizen and political scientist who is acutely, as I said yesterday, concerned about the risks that AI entails. But I can wear both hats comfortably because I do believe that there are answers to reconcile both of those to help us reap the benefits of AI while mitigating the risks and that there are principled answers at hand.
You're an optimist.
And the other thing I should tell you is that in my living room, given my country of origin, we serve ouzo and not wine or beer.
Yes, I gather it's still classified as a wine. Ouzo. Never quite understood that. Listen, you've been here throughout. What's your takeaway?
So, given that this is my living room and I'm among friends, I'll be a little honest on a couple of things that have been on my mind and building up over the past 15 years, working at the intersection of AI and the law and public policy. The first thing I would say is that, AI is science, in effect, and that science and the law have something in common that is incredibly important to the well-being of humans, and that is a truth-seeking mission. Both seek the truth. And so one would imagine that this would be a marriage made in heaven, loving, mutually respectful, and it turns out that it hasn't been, in a way that is destructive, I would say, to the foundation of the legal system. And the question is why? And what is the dysfunction? And what we've seen is, in fact, I would say, even a lot of ongoing domestic violence going on, and it's unidirectional. It's not from science directed to the law and the practitioners of the law, it's from practitioners of the law towards science, and I'll give you a couple of examples of that. We talked a lot about Compass yesterday, and I was a little surprised myself to find myself on the side, against my instincts and my heart, of North Point, who actually I thought, was working within the system, was telling people how to use it, how not to use it. And I thought this company is right. They should not be held liable. But then at the same time, that raised the question of how can we possibly live in a system that tolerates that human beings can be, in part, judged by technologies for which there is absolutely no evidence of effectiveness that has been offered by US NIST or by other fora of equal quality and reputation, based on a consensus scientific protocol of assessment of their effectiveness. And so we have procurement systems and courts and law enforcement agencies that are able today to use technologies that are unproven. In fact, we talked a lot about the FDA. We have a sort of FDA that's been used in civil justice, that is NIST, and I talked about it a bit yesterday. Well, NIST can design protocols to measure the effectiveness of these technologies. There is no such studies have been done, and yet in the law, every single day, we're subjecting humans to technologies for which there is absolutely no proof of evidence and depriving people of their liberty. Every day this happens, it is a punch in the face of science that is delivered by the legal system. Another example I'll give that I think is very similar, that I think is even worse in a way, is what's happening in civil justice. In civil justice, we use AI, and that's me with my entrepreneur hat, to automate decision-making when it comes to review, to document review. And this is in advancement of, again, the truth-seeking function and the fact-finding function of the law. It is vital in resolving legal disputes. And NIST showed nearly 10 years ago a couple of interesting things, that AI can actually work for that purpose. And the studies suggest that it can do so if it is used and deployed and measured by experts in the field. And in that way, it can help access to justice by accelerating the process, by producing better than human results. I mean, this is the science of it. And the second thing it showed is that it's very actually hard to measure your accuracy, and that lawyers and techies who try their hands at it, who are not statisticians, fail terribly at it. And yet every day, and I'll go quickly because I'm not the only panelist, I realize, but I think it's a really important point. That science has been available for 10 years and it has been completely ignored. Every day my company is involved in supporting, meet and confers where we can see attorneys making up their own statistics. I mean, I think you all know the aphorism about, lies, damn lies, and statistics.
Some think we have a president who does the same.
That's right. And we forget the fourth part of that aphorism, which is made up statistics, which is even more pernicious. And made up statistics that in the legal system we believe. Every single day, judges will believe that parties that negotiated, technology-assisted review and are promising each other 75% accuracy simply do not understand the statistics they're talking about. And everybody pretends that they do. And so here is a case where for 10 years, the science says that lawyers are practicing science without a license, and that is to the detriment of the fact-finding mission of the law, and we let that happen every single day across the country in courtrooms everywhere. And to me, this is absolutely intolerable when we know that, again, to end where I started, that the truth-seeking mission of science is so supportive of the truth-seeking mission of the law, and that should work better.
Jeff, speak for the law. He threw a rather large rock at the profession. Is it simply a byproduct of the adversary concept that lawyers are advocates, they're adversaries, they are not, when they function in court, truth seekers?
Well, what I took away from my panel and the panel I moderated and actually all the panels that I attended was that there is a kind of a historical process to this development of artificial intelligence that is on the same trajectory as all kinds of really innovative technologies. This relates to law, but there are three parts to this. So when a new technology comes in, you get the phase of ooh la la, that's my term for it, which means, oh my God, this is so wonderful. This is amazing. It's going to revolutionize everything. And it's associated with a narrative that's a utopian narrative. So just to place it in historical context, like I'm doing, there's a novel by the futurist H.G. Wells that was published in 1923 called Men Like Gods. And in this novel, a guy's he's tired of his job in the city, he takes a drive in the country, and suddenly he's transported 3,000 years into the future. And he finds himself in this wonderful society where there's peace, there's prosperity, everybody gets along, there's no racism, there's no sexism, there's no bias, everything is absolutely spectacular. So this is the utopian narrative of the future. And this is the first stage when a technology comes in. And it's also associated with regulation, which is that we ought to let regulation, we should not regulate these technologies. We should not stamp out this developing process before it's had a chance to grow. That's the first stage. The second stage is the oy vey stage. So in the oy vey stage, people go, oh my God, what have we created? This Frankenstein monster. And this is associated with a different narrative, which is the dystopian narrative, not the utopian narrative. So this dystopian narrative is Aldous Huxley's Brave New World. H.G. Wells was 1923, Aldous Huxley was 1931. Remember Brave New World, you probably read it in high school, if not more recently. But this is a world where, because of genetic engineering, we talked about that this morning, everybody has been turned into a genetically modified perfect person. There are differences in intelligence, but those are carefully modified and people are put in different classes based on their intelligence. And he presents this as being, in a way, a utopia, but it turns out to be a horrible, nightmarish dystopia. So that's the second phase. And that's associated with, let's regulate these things. When they're out of control, we need to regulate them. And then the third phase is the plus ça change, plus c'est la même chose stage, which is, yeah, it's really the same as it's always been. And I see that in the internet, for example. It was going to change everything. And then, oh my God, we're kind of in that stage now. And I think eventually people will say, well, yeah, it did change a lot, but really it isn't doing anything other than what's been done in other ways in the past. So where do I see AI in this? I think AI is between the ooh la la stage and the oy vey stage. We're moving in that direction. And that's why I think we hear on many panels this tension between the utopian narrative and the dystopian narrative. We heard it in the panel on judges and other panels. So we're moving. And I think we have a little bit more of the dystopian phase to go through before we get to the phase where it simply gets integrated into our life and we accept it as part of reality. So for lawyers, Arthur, we lawyers, and I speak for myself as well as the profession, we're always behind the curve in terms of technology. And we're followers, we're not leaders. Technology is the leader. So it's our job as lawyers to not fall, recognizing that we'll always be behind, to not fall too far behind. And I believe this conference has been a step towards helping us catch up a little bit.
It's not only that lawyers are behind, and this goes to a theme that has been voiced throughout this conference, and that is the question of regulation.
Right.
And the hopes that you can educate legislators to regulate intelligently, a premise that has never been proven. Law is always behind science. Nicholas, I think you and I have had this conversation. Law is a reactive profession, and the system of the profession is reactive. And I used to teach copyright law, which you know. And it has always amused me that every copyright statute this nation has enacted from the year 1790 to the year 1978 has been obsolete on the day of enactment. In 1909, we had a Victorian statute, but a beautiful statute, Copyright Act of 1909. And then what happened in 1910? The phonograph record appeared. I sat as a commissioner on the Commission on New Technological Uses of Copyrighted Works, 78 to 81. Can you copyright a computer program? What is the copyright status of photo duplication? What about machine-generated works? What about artificial intelligence? Well, we made recommendations to Congress, which Congress perhaps foolishly adopted. And guess what? Suddenly the chip appeared. And networks and computers went from large mainframes to distributed networks. It is a fact of life. We, Jeff and I, and David, and in a sense Julia, we're always behind the curve.
Well, I read a book of science fiction that was talking about a dystopian future where humans would be stripped of their dignity by virtue of being stripped of their privacy because of the emergence of technologies that would allow the creation of digital records of everything that we do in our lives. And that book was called The Assault on Privacy. It was written in 1971.
What year?
Pardon me?
What year?
1971. And
I just wanted to make sure everybody in the room knew that.
Asimov, it was by Professor Miller, who has been warning about most of the things we talked about over the past couple of days in 1971. 11 years ago, we worked together on a big data and emerging technologies summit that touched on similar issues, in which we had the honor of having Justice Breyer join us on a panel exactly like that. These questions have been in discussion for a very, very long time. AI has been adopted in the wild, and I fear that we are setting precedent, especially in the way obviously the law functions and the reliance on precedent, that will, if it has not already, impeach any attempts at future governance of AI. So from my perspective, recognizing the stately pace at which the law has to go, it remains intolerable that with the scientific evidence we have in the case of civil justice and that we don't have in the case of criminal justice, that every day in courts everywhere in the US, people's lives and futures are affected and undermined by not utilizing the instruments of science in sort of these time frames.
It's only been 2 generations since 1971, but there is a risk of prematurity. I mean, trying to regulate a developing phenomenon, whatever that developing phenomenon is, like shooting crap in the dark, where the crap shooters are undereducated and the experience base may be damn near non-existent. I don't know. Julia?
I think that we're really at a point where we need to change how we're thinking about working on these problems. I agree that lawyers are, as a profession, woefully behind the scientific times. Most of us have, fingers in our ears and our hands are over our eyes. People are talking about, I'll retire before I have to worry about that new technology, and they're talking about e-discovery and whether they're doing it right? Mm. So, but that's not all lawyers. That's, I think, the majority, but it's not all lawyers. We heard yesterday on the lawyer panel from lawyers who are engineers and computer technologists, and they're working as lawyers with the backgrounds and skills that are needed to work alongside the business. So I teach technology and the law to technology professionals because I believe that technology professionals and the non-competitive school uptown believes that technology professionals need to be more integrated into their business organizations. And one of the aspects of that is the law and understanding the legal impact of the technology choices that are made or not made, or called made, at a company. So lawyers working with technologists becoming more aware of legal consequences, that model, I believe we need to be integrating into law schools where the lawyers are becoming much more aware of the technical issues and the technical expertise that's needed to be able to advise their clients so that we're knowledgeable about when to bring in expertise that we don't have personally. I really think we need a dramatic shift in how we think about that. We graduated from law school very proud of ourselves for being so smart and knowing so much. And with the speed of change, the answer right now, the fact is we don't know so much.
Now, David comes from a law school in a galaxy far, far away. Julia's last point, law schools are trying to catch up. I'm not saying they effectively are, but your school, my school, even the school uptown, has recognized we are in the 21st century. And we've become more interdisciplinary, particularly in terms of technology and law. What's your biggest concern?
So let me start by saying that, I came into this conference thinking that the solutions in this area were going to be interdisciplinary, or that if we're going to think about this in a wise and practical way, we're going to have to approach it with a relentlessly interdisciplinary lens. And it's just clear at a substantive level that getting to smart decisions about how we regulate AI will require that interdisciplinarity. So, to take an example from the project I'm currently working on, when the EPA or the SEC uses a little ML tool to engage in predictive targeting for purposes of making enforcement decisions. How do we treat that legally? Right? The Administrative Procedure Act and interpretations thereof say that those sorts of decisions aren't judicially reviewable. They're committed to agency discretion, but maybe with an ML tool in the mix, that doctrine will give way. And I could imagine that judges would want to know the details of exactly how that tool is being used, and that whatever we decide as to whether that should be reviewable or whether it's arbitrary and capricious in the manner that it's applied in a particular case, that the legal conclusions that we arrive at are going to turn hugely on technical details. So it's absolutely clear that lawyers are going to need to be able to understand the technology in order to argue in any kind of coherent way about what the legal principles should be. And so I guess my biggest concern is that we won't do a good enough job. By the way, I'm a legal educator. I long ago gave up on trying to move the dial out into the world on law and regulation. I think everyone has that aspiration where they sit, when they sit where I sit. I've now decided, well, maybe the value that I can add is through education. So it's something I think hard about then is, how do we effectively educate lawyers for this future? Let me say one more thing, and then I'm going to give you some examples, which is that it's very possible, having led a panel on how we regulate AI, that the solutions here aren't going to be legislative at all. They're not going to be legislated. They're going to be litigated. It's possible that our do-nothing Congress will never do anything. And as a result, a lot of our effort to regulate AI, to inject ethical principles into the use of AI, will be a litigated question, not a legislated question. So that just kind of amps up the notion then that we need to educate lawyers. So what's going on at Stanford Law School to try to educate lawyers? Well, we're trying to think about how we infuse our curriculum with tech. And my view is that that doesn't mean teaching a class called AI and the Law. Indeed, maybe we teach that now, but if we're still teaching it in 10 years, it will have been a massive institutional failure, because instead what we should see is AI questions, legal questions that circle around AI are actually a pervasive part of the curriculum. So one of the questions I have is, how do you get from here to there? I also think it's really important to bring law students and lawyers in training into dialogue with technology, and in particular into dialogue with technologists. And the current project I'm working on is a great example. So I'm actually running it in the winter as what's called a policy lab at the law school, which brings together students with faculty leadership to try to solve problems out in the world. Generally, the idea is to have a client out in the world. So in this case, the client, as I mentioned during my panel, is the Administrative Conference of the United States. And I currently have 20 students enrolled in that policy lab, and 10 of them are law students. 3 to 4 of them are GSB business school students or political science grad students, and then 6 or maybe 7 of them are computer science PhD students. And that's a high-powered computer science program at Stanford. And so as we work through the implications of federal agency uptake of these AI and ML tools, we're going to have lawyers in training sitting across the table from CS PhD students and actually trying to get under the hood of the particular tools that are being used, actually understand the guts of the technology, and then understand maybe how the legal principles might apply. And so my concern is we'll do that poorly. That's an example of maybe a way to do it well. Unfortunately, it's not a way to do it in a scalable way. And so again, part of my role as Associate Dean right now is to think, okay, what else can we do that has more of a systematic, sort of cross-pan-curricular feel that can, help develop these tech skills in our lawyers, and in particular train our students to talk across the law-tech divide.
Of course, the people bred today in law schools, whether yours or ours, speaking for Jeff and myself, it will take them pretty close to a generation before they are in a mature enough position to affect policy. What do we do with the fact that we've got to make some policy between now and then? We've got a time warp there. Because as pointed out in the earlier session today, the people sitting in the halls of Congress, The people sitting on the federal benches, let alone the state court benches, where well over 90% of the judicial business of the United States is conducted. And the people sitting on the agencies and commissions, whether it's SEC, FDA, FTC, they are going to be making policy. Of necessity, they will be making policy for a decade or 2 decades before their successors will have the technological savvy to know what the hell they're doing. Otherwise, we will have, as I've seen over time, statutes enacted that are absolutely obsolete on enactment. What do we do? What do we do?
If I can interject, and you'll tell me if I speak too much as the good moderator that you are, but I think there is a range of things. So clearly part of it is legislation, regulation at the one end, and this will take time, it's complicated. I think what's most immediate and present is agreeing that we can be impatient with judges and the legal system and lawyers pretending at this point to not know the self-evident. So for example, judges in meet and confers will always let the parties decide when it comes to use of AI in discovery what level of accuracy is appropriate, and parties pretty much can do whatever they want and agree to whatever they want and have whomever they want negotiate what the protocols are to do this crash test, really, to measure how well AI is doing. And the simple question they could ask is, if you agree to 70% accuracy in the use of your AI, so that I can believe that you're finding the facts that you're supposed to find, who designed those protocols? If it's a lawyer, go back, start again, find a statistician with the right credentials. That is not too much to ask 10 years in, 15 years in, and to ask lawyers who are so conscious of the need to, practice your own craft, and to recognize that statisticians are actually a different craft practicing different. So that is something very simple, and I think also for those who teach ethics to lawyers to really help them recognize that just as they are concerned about the risk of technologies practicing law without a license, which is, I think a potentiality, but not a risk that has materialized, that every day today we have lawyers practicing science without a license, and that is extremely dangerous. So that's one thing. And in the middle between these two, I want to refer the industry initiatives, such as the IEEE Global Initiative I mentioned yesterday. I chaired its law committee. I think it's really getting this right in terms of creating the sorts of interdisciplinary efforts we've just heard about that I think are crucial. And I'll just mention there that the work of the law committee has actually resulted, and it's a preview on our work, and this is not the official IEEE position, but over the past couple of years, it arrived at 4 principles inspired from how we govern actually human intelligence, to say here is how we can actually trust AI in the law. And these 4 principles, we're not going to discuss them unless you have questions, but part of it is transparency, which everybody talks about. Part of it is accountability, everybody talks about. But the other 2 is proof of effectiveness. Does this thing actually work in the circumstances in which it is applied? And 2, is the operator of it actually competent? And the answer to that question, as you've heard me say earlier, for now is no, they are not, and this is very dangerous. So these 4 principles are the heart of our work, and I think these can be operationalized promptly.
Go ahead, Jeff.
Well, we've been talking about the need to educate lawyers and judges, bring them up to speed, and I think that's really important. But I think the problem is deeper and actually intractable, because law as an institution, as a discipline, is inherently lagging. It simply cannot be at the forefront. There are 4 great, as I see it, 4 great forces that move history forward. One is technology, one is markets, one is politics, and a distant 4th is law. What moves history forward first, I think, is technology. But it's hardest to see because it operates in the infrastructure, so we don't observe it. Politics and markets are second. Once those have changed, then the law comes in to make adjustments. But it is inherently part of law that we are lagging and we should be lagging in a way. We can't be leaders in this. We heard this morning, I thought quite interestingly, about subtractive versus additive technologies. And law is an additive technology. We don't invent laws and then subtract from them to adjust for what we've learned. What we do is we build the law up based on what we've learned, but there's always further to go. And it's just necessary, I think, that we are lagging, but our job is to lag as little as possible. So that was what I would add.
And that's what you mean by intractability?
Yes, it's intractable because law as an institution will always lag markets, politics, and technology.
Well,
So I would challenge
Sorry, go ahead.
that slightly, although I agree with what you said as far as it went. It's the absolute nature of your position that I disagree with. First, lawyers are advisors, and we're advising business as it's making its products. And we have a wealth of knowledge, as John Burkett said yesterday. We don't need to change tort law. Well, he said we won't change tort law. And my response to that call was, we don't have to. We just need to change the definition of the duty that tort law recognizes as one of its underpinnings. What's the duty that we have as people in this society to create machines or algorithms or uses that are going to impact human rights? What is that duty? That is going to have a new definition. Those are new facts, and so we'll be interpreting that. And lawyers today are perfectly capable of interpreting and guiding business in the interpretation if they understand the underlying facts. So I think we need to, when we talk about education, there's not just legal education, there's education more broadly. What are, and we've heard about this at the conference, what are these different kinds of algorithmic tools that are in the marketplace? Let's divide them into different kinds of categories. Let's not lump them together as one and say it's all impossible. We need to start distinguishing.
you believe that?
I can keep going if you want.
Oh,
If nobody wants to disagree.
No. I cherish controversy, but I don't want to shortchange you, Julia. I mean, what you're describing is indeed the common law process. That there is a phenomenon out there. You don't know what its dimensions, ramifications, contexts are. So you, as Jeff said, you build.
Right.
You take this set of facts, make a decision about this set of facts. And then when another set of facts emerges, you try to bridge,
Right.
try to
But
take your doctrine and refine it.
Right, on the advisory side, though, not just on the reactive litigation side, right? Or in the advocacy side, we're trained as advocates. We should be, along with our clients, in front of the regulators talking about these issues. I think if we sit back and wait, it's going to be way too late. This technology is moving way too fast, and the implications on our society and on our humanity, I think, are implications that the public doesn't generally understand, right? Everybody who's signed or clicked the click to accept button without reading the terms was lacking information, and even if they read the terms, they would have lacked information on the impact of those words that said we're going to take your IP address and some other anonymous information, and we might aggregate it with something else, and we'll learn a little bit about how to make the tool work better, right? Because that's what the terms and conditions say, essentially. They don't say, we can't anonymize this. We're going to aggregate it with other information that's going to make your personal identity known, identifiable, and we're going to aggregate it with things that could affect your ability to get a job, your ability to get medical treatment or insurance, your ability to get housing in the place that you want to live. And people didn't understand that. And I think there was a lack of, there still is a lack of awareness about the impacts. And we need to change that immediately.
That's a massive educational problem.
It is.
Because
So who learns that?
It's what in effect, arose during the mock trial yesterday. The fact that the user manual described a lot of the limitations on the program.
But even
But
more,
there's no reason to believe that anyone, let alone everyone using the product, will read the user manual.
true, but I want to make a distinction. The court was the user. Okay, and I understand in the lawsuit yesterday that the decision was made to sue the manufacturer, not the court. But the court was the user. The impacted person was an individual in society who was being taken out of his neighborhood and put in jail for a longer period of time, right? So the impacted person had no chance to read any terms and conditions. And in fact, essentially when the user tried, right, to get underneath it, it was turned down, right? So that's a judicial misunderstanding that led to that result, in my view, lack of education of the courts and lack of education of the lawyers, perhaps who were arguing, because they weren't able to argue convincingly enough. But among the people who need to be more fully educated, it's the non-users, too, right? It's the people who are driving in the car that has the camera that's recording the fact that they're there and they didn't buy the car, buy the camera, etc. Right? So it's broad.
And that goes to the question of, it brings up two questions. One is the question of externalities and to the limitations of contractually dealing with those risks, right? Because a contract really distributes the risk between two parties, but without thinking about perhaps the impact on others. The other one, I think, is a question of culture related to education and the openness that the law has or not to input from the outside. And I say that, I must come across as somebody who dislike law and lawyers, and it's the exact opposite. Some of my best friends
are lawyers, right?
Yeah, some of my best friends and best clients are lawyers. So, but as a political scientist, I treasure the role of the law. But the question of culture is an interesting one, which is I've had this sense that the legal profession reacts a little bit as a guild, as an inward-looking community, and I noticed that with the recent attempt by ISO, which is a global standard-setting body that developed over a long period of time with input from a great diversity of folks, including lawyers, a set of recommendations for e-discovery that were actually sort of very gentle. These weren't standards. They were just guidelines for attorneys and judges to be able to look at that said, well, if somebody comes in front of you and is using artificial intelligence, here are the questions you'd be asking about the competencies of the user, the evidence you have that this works, and so on and so forth. And what I've seen in a number of legal conferences across the country I've attended was effectively a reaction of who are these people, and they're not going to tell us what to do. And that cultural issue, I think, is really, really challenging, in part because lawyers, again, are not scientists and do not understand the areas involved, and in part because I think it reflects a little bit, I think, a loss of perspective on who serves whom. Society doesn't serve the law serves society. And lawyers, legal scholars, judges have a responsibility to make sure that they don't forget their accountability towards society. And so when we talk about the law lagging and the legal profession lagging, I agree with that. I mean, lawyers have to be, and the law has to be conservative, but it has been 15 years that we use AI in discovery, and every single day science and the rights of people and of companies who are affected is being done violence to, because the self-evident hasn't yet been absorbed in the civil justice system, and that is intolerable, again, in my view.
Well, Julia, you make an interesting point in drawing a dichotomy between the user and the third persons, the anonymous third persons who may be affected. That's important. But even the user needs more protection. We have in this country people who have no extensive education. Their ability to comprehend is limited. We also have in this country people who really are at a level indifferent to the information that's made available to them. How many people in this room have read the agreement for your cell phone? Here we have the smartest of the smart, and it's a small fraction of the room. How many of you have read the agreement for your credit card? A few more. How many of you, as you're racing to an 8:30 business meeting in a foreign city, have read your hotel bill with care and have asked what these strange 18-cent entries for IMS are? See, that one stumps everybody. 18 cents, what the hell? But of course, 18 cents multiplied by 100,000, that's real money. What I'm suggesting is that the law's assumption about contracting and agreements is just totally fallacious. The assumption that a mature business like H5 contracting with a mature client like a mega law firm, that's a reasonable assumption. But when you extend those notions of comprehension, education, language, they're fallacious. Here is the law in 2018 validating adhesion contracts day in, day out under principles 300 years old. I don't know that we can ever jump that barrier.
I don't think the solution is just in the contracts, although I have to defend our H5. Our contracts are about 38 pages shorter than the cell phone contract. The issue, you said something about, I think fairly, that people have different education and different context, but everybody, if they have information presented, is smart and able to absorb that information. What we've been doing, I would say yes.
Everybody?
Perhaps your 3-year-old niece might have a trouble.
Well,
right?
how about
So,
the 7 to 20 million people for whom English is not the native language?
Well, I know you're taking it to an extreme. One might give them
Just
information.
20 million is
Here's my
that
point is it's
extreme.
not about the contracts entirely, right? We're in
No,
a
I'm
Canadian
agreeing
society.
with you on that, which is why I accept and admire the dichotomy between the facial user and the third person whose life happens to be embedded in the database
Right.
that you may be selling or buying.
Right. So how do we, my question would be, how do we change the knowledge level of the diverse population in this country so that citizens are aware enough of what's happening actually and what may be coming with some kinds of technology and how it is affecting or may affect their rights, to be able to speak up at a local level to their political advisors or political representatives, and to speak to business and to have an impact on the way that we're steering the ship. Because if we wait for the litigation after somebody's hurt, it's way too late, right? We're affecting rights
Agreed.
dramatically and quickly.
You're really
Way too
asking
slow
two
and change.
questions, at least two questions in one. The first is, how do we get everyone to understand? And here I'll piggyback on Jeff's early word, intractable. I think that one is intractable. The second question you're asking is, how do we get policy decisions affected by pressure to achieve more equality of treatment? I think
Right,
those are two different questions.
Well, I think you could make them two different questions, but the question for us as a society is how do we solve the bigger problem
Well, let them-
of information?
that-
I don't think I can hide behind the law to say, well, but it's too hard to do it as a lawyer. Well,
And I don't
have
think
to
you
be
can hide
changing laws
behind
to do it.
education, because
Right.
education is even slower than the law.
Right, but there are
And it's not
people in the
universal.
There are people in the room, and there are even bots that are writing all the articles we read on the internet. We just train the bot to go write thousands of articles about the evils of artificial intelligence.
Wonderful. So now you're talking
We get the information
about
out there. I'm just
changing
kidding, but-
public policy through pressure of one form or another. Part of it is by appealing to intelligent people, part of which is putting pressure on the decision makers, who are, of course, vectored and pressured by competing people like industry. So now you're talking about the way our Congress works in the few years when it does work. I mean, we're all safer in a sense when Congress does nothing.
People
could I-
pressure industry too. People don't just pressure politicians. So
But they don't make contributions the way industry does.
Sure.
Let's be realistic about it.
I wanted to try to deny the premise that a user manual is actually needed for the user. So in courts today, or in law enforcement, the correctional system, we have users who we don't know what their qualifications are, so they need the user manual. Usually we trust a pilot when we get on a plane, because by that time they don't need the user manual, right? They are professionals at that, and it's the reason why we trust them. And so that goes to, again, this question of competence and of who is actually qualified to operate the given technology. And by the way, that's why I'm glad that IEEE has another initiative on certifications that will include that. So that's one thing. And on education, I also want to make sure we think about it, or at least the way I think about it is, I run a company. I certify that my financial statements are accurate. I'm not an accountant. And society doesn't think that people like me should be educating in accounting to the point to understand GAAP, and that I myself can actually, produce our financial statements. All I need to know is that accounting is a distinct competency, and that I need to have an accountant, which I do, and an excellent one, and that therefore I can trust that accountant because of their experience and their competence and the technologies they use, that they know how to use, and for which they no longer need the user manual to produce compliant financial accounts. And the reason I'm saying that is, from my perspective, education starts and ends with lawyers and judges recognizing that artificial intelligence is not the law, that you need the right operators, you need the right metrics, you need the right scientific expertise to do it. And it is not too much to ask for that piece of information to have been absorbed 10 years ago by the legal system and lawyers who actually recommend to their clients the use of AI. These are not students in law school who are starting to learn. These are people who will tell their clients, this is the approach you use. We as a law firm procured this type of AI, and we're having our attorneys use it. And they don't know that AI is a distinct science. They don't have a duty to know if actually at the wheel of these technologies that they use to serve their clients, but also they have a duty to the court to actually make representations that they've actually done a reasonable job of discovery. They don't know that they don't even have the competencies needed to operate those technologies. This is not 10 years of education to become computer scientists, just like I didn't undertake 10 years of education to become an accountant. I'm not, right? It was accounting 101 when I went to business school, that, accounting is a distinct profession. That's it.
Go to the microphone. Go ahead. Who are you? Speak
Jared.
into the mic.
My name is Jared. I'm an artificial intelligence researcher, and I'm very interested in the question of agency and what we're examining. We've muddled the discussion a little bit in thinking about, whom we presume to act. Is it, lawyers as a profession, or computer scientists, or policymakers, or the users? I don't know. We could apply actor network theory or something like this in order to examine, do we If our aim is to apply a certain, frame of normative ethics, perhaps as espoused by the IEEE, then do we put the arm on, the general public? Well, no, like Cormac Hurley and, so long and thanks for all the externalities would say that the application of all of the recommendations of privacy researchers is patently absurd on the user base because it's so many things to pay attention to. This is the intractability of education. I would take the unfortunate, in my opinion, case that it is through the corporation, just as Nicholas says, and through the kind of learned bodies, as is this one, that we're able to advocate and apply pressure most accurately. It's where we see at Google the ability of the engineers to say, we don't want to do this, that we're able to see that frame of ethics applied through the agency of the workers. And I'm just interested in, what we think about that.
All right, there's a universe of potential obligees, so to speak. There are professional ethics, there are industrial ethics, there are legislative ethics, administrative ethics. As you think about this world, where should the buck stop? Who should be held responsible? We won't talk about the nature of the responsibility, whether we apply capital punishment or not. Who is responsible for the quality of data and the quality of the use of that data in artificial intelligence? From a policy-making point of view, what should we be thinking about? Jeff?
Wow, I got called on. I think that, you mentioned how many people have read their cell phone contracts, and very few people raise their hand. I actually think that we have a right to privacy, and we also have a right to ignorance. Most people don't want to read their cell phone contract.
Right.
Most people would be annoyed if they were required to read their cell phone contract. So this is something we keep using the word intractable. That can't be that we're going to have people we can't force people to do what they don't want to do. So we need to have some intermediaries who will perform the function. And you ask who, where does the buck stop? I think using a word that's popular these days, it's distributed. Lawyers have some role. You mentioned accountants, scientists, people in AI like you. There is no one responsible person. What we can hope is that the whole is more than the sum of the parts, and that working together, we will achieve not perfect accuracy of data, not perfect ethical use of data, but at least enough that the benefits of the data significantly outweigh the costs.
David?
So I agree with Jeff that this idea that it's a distributed obligation. Absolutely. I could add a little bit to what I said before about what we could do within the university to make things better. Then, if it's true that intermediaries are gonna carry a lot of the water here, then we need to train technologists. I can tell you, I don't want to be too jingoistic here and talk again about Stanford, but there is a class that is being rolled out in the winter that is ethics and technology, and it's specifically targeting computer science majors, and there will be hundreds of people in that class. It's taught by one of the most prominent and one of the most popular CS professors, as well as some political scientists. By the way, it's colloquially referred to as practice safe CS. And, if you want to try to move the dial in terms of technologists, computer science folks taking on board some sense of, the ethical challenges that are baked into what they do, then, Stanford is a pretty good place to start because there are an awful lot of majors. There are now 2,000, I think, CS majors at Stanford at any given time. That's a huge number of people. All the humanities are shrinking, even the social sciences are shrinking, and CS just keeps getting bigger and bigger at Stanford. So if you want to move the dial, that's a way to go about it, and I think that maybe helps to educate one important set of intermediaries. As to other possible intermediaries, of course, I think it comes back to lawyers. And so there, I think, if we're worried that there's a lack of awareness or an inclination or a lack of an inclination to know about the terms of those agreements. Well, who does have an incentive to know about the terms of those agreements? The answer is plaintiff's counsel. And so there we may be concerned about the constriction of the class action. This is, of course, something that Arthur knows plenty about.
You've ruined my morning.
But the court's recent enforcement of class action waivers within arbitration agreements, which brings in also the arbitration question, not just the constriction of the class action, but also the arbitration alternative. Like, we should worry about that then if we want lawyer intermediaries to carry water here and to try to, as I noted, litigate the ethics of AI. It seems like that's a loss for us socially. I realize there's social costs to class litigation, but that might be a really pointed example then where, we should be worried about the broader tectonic moves within American civil procedure. Let me say one more thing, which is that I think all of this, like thinking about like the who's going to carry the water, or maybe the lack of general education within society about AI, and even an inclination, the lack of an inclination to even learn anything about it, is a really important point, and I think it relates to something that I, as a relatively new entrant to this whole debate, have thought about and focused on a little bit as maybe a good way to think about all of this. It concerns the transparency concern when we have AI and ML tools. And in my view, we should be thinking about thick versus thin transparency concerns. So a lot of the discussion at the conference so far, yesterday and today, concerns what we might call thick transparency concerns. So, the black box nature of AI, or the self-adaptive nature of, especially sophisticated, AI tools and techniques. Maybe even like data input problems. That's a thick transparency concern, because if we don't know the baseline offense rate in the Loomis context, there's no amount of statistical adjustment that's going to get you to the right answer. Those are thick transparency concerns, and they're very real. But I wish there was more attention to what we could call thin transparency concerns. And the principal one there is that just it's a thin asymmetry in expertise, right? It's the fact that the general public doesn't know much about these things and has little inclination to know much about these things, and that's a problem, because that affects jurors, right, who are the backstop in our legal system, and then it also affects citizens who, as we've discussed and as prior panelists have noted, are really have to be the source of political pressure.
And you should throw in judges. See, when Nicholas appropriately castigates practicing lawyers who are practicing science without a license, you've got to throw the judges into that category, because the judges are just as undereducated, by and large, this is a generalization, as lawyers. The interesting thing about the judges is when Nicholas refers to those meet and confer sessions between the lawyers to develop the discovery plan, the judge then abdicates. When you think of distributed responsibility, you've got to consider the possibility of abdication of responsibility. Okay.
Good afternoon. My name is Rosie Von Leela. I'm not an attorney, but I'm the next best thing, a future legislator. And to follow up on what Julia was saying, talking about the negative externality of Loomis being the third-party negative externality, and getting to this point of there being a communication issue, that's really what we're talking about here, because our credit card terms or our phone terms are often written in a way to obscure information rather than communicate. I run an organization, we do education work through a communications tool that all of you would be familiar with. We use comic books to educate judges, to educate the general population, to educate young students. And I will tell you, one of our team members created 2 pamphlets that were responsible for pushing a new law through New York State that Governor Cuomo signed in August. So I would invite you, as attorneys who are supporting companies and putting communications out there, as people who are running organizations where you really do care about the general public, understanding what they're signing up for or participating in, consider that there are communication tools aside from long paragraphs of legalese that very few of us enjoy reading. Thank you.
I agreed with that.
I think everybody should really listen and review very carefully to the last two persons who were at this microphone who made points.
Hold the microphone.
I'm sorry, the last two speakers who made points that really require serious consideration. If you ask me the answer to the questions that you've been asking, I would probably, because I don't really like standing here for any length of time, I would tell you that what you need to do is to reverse Citizens United as the first step of dealing with it. But the problem is, this is a problem of government. This is a problem of government to protect the people of the United States. I don't have to read my credit card things. I don't have to read any of these things because, in fact, they are contracts of adhesion that are one-sided, that the courts should have not allowed in their fullness. And if they had done this in the first place and had dealt with these things, we wouldn't be dealing with this. We would not be dealing with these ridiculous arbitration provisions. Why would I read this when I know where it's going? And this is what government is supposed to be about. It's supposed to protect the people. And when it doesn't do this, then we have conferences that say we have to train lawyers to do more than this. We have to train judges to do more than this. The answer is it's the function of the entire government, and that is, in part, the function of what law schools need to point out, that this is the function of government to protect people when there's unequal power, when there's unequal, when there's an inequality of bargaining power in making contracts and things.
Okay, I agree with every word you spoke, as I think David does.
I could say briefly that, as a matter of, American political development, right? That's a subfield of, I have a PhD in political science, so that's where we think about the long-term evolution of American institutions. It is unfortunate that this incredibly important wave of technologies is coming online at a moment when our political system is in such turmoil. Right. And, I guess I agree with, Jack Balkin's view that, our system has progressively gotten less democratic and less Republican over time. And, the democratic aspect of it is that it's less able to translate preferences, and in particular the median voter's preference, into policy. That's a democratic deficit that I think has opened up for a variety of reasons. It's also become less Republican, which is that our entire political discourse has been focused, is less organized at this moment in our history than it ever has been around some notion of the public interest. And that's a real loss as well. And so we have this political system that is just so constrained right now, and yet we seem to have these really big regulatory challenges in front of us and ahead of us.
Final thought, Jeff, any final thoughts? This is not obligatory. Nicholas?
Maybe on a point of personal privilege, I should say I wasn't castigating judges and lawyers. I was maybe perhaps gently encouraging them to think differently. But,
Julia?
Projects that don't have someone with accountability, a central person with accountability, don't get finished. And we're talking about, and while I agree that there's distributed responsibility, I don't believe that's enough. We need to make changes now, or it will be way too late to save our sense of humanity, in my view. Yes. So I don't have the answer. We need the answer really fast.
That's David's point. The need is gigantic. It's immediate. It comes at a moment in which society, politically and legally, is in a state of paralysis.
I think Jared should create an algorithm for us that assesses what has been most successful in the past in taking distributed responsibility and bringing it to something that was fruitful.
And hopefully the word distributive will be spelled correctly. All right. Our bull session has ended because the clock has moved. Thank you. Thank you.
Thank you.